Hello, everyone, and welcome to Internet Law Review. I hope you're having a great day today. How's everyone doing? We are going to read an article, and then we're going to watch what the article refers to. The article is like our amuse-bouche, is meant to whet the appetite for what is to come. And then we're going to watch about 11.5-minute compilation video that this article refers to. And I think it's great because we get to see how the passion is drained out in the written word, and then we get to see how it actually happened in the real world. And I think you'll agree that while the article is a somewhat literal recitation of the facts, it doesn't quite capture that essence of what we're looking for. So we're gonna read this, and then we're gonna watch this video, and we're gonna have a group reaction. So prepare your favorite emojis, people, because we're getting real. So this article is entitled Lewandowski Hearing Descends into Chaos. This happened today. The House Judiciary Committee is having a hearing on something that they are saying is impeachment hearings. I don't know. But we'll just read what the article says, and then we'll watch some of it. Corey Lewandowski jumped to President Trump's defense on Tuesday, today, because during his testimony before the House Judiciary Committee, blasting Trump haters and making clear he will not answer questions the White House wants him to avoid. Lewandowski, a former campaign aide to Trump, who's close to the White House, took aim at Democrats and former special counsel Robert Mueller's investigation in his opening statement, describing the probes as harassment while alleging that some critics sought to bring down the president. Sadly, the country spent over 3 years and $40 million taxpayer dollars on these investigations. It is now clear the investigation was populated by many Trump haters who have their own agenda to try and take down a duly elected president of the United States, Lewandowski said in his opening statement. You just feel the pump is getting primed here for this show, Dad. Seeding the well here. This is. As for actual collusion or conspiracy, there was none. Where there has been, however, is harassment of the president from the day he won the election, he continued. The Democrats who lead the House, I'm sure, were thrilled with this, right? The committee hearing quickly descended into chaos as Chairman Gerald Nadler of New York sought to question Lewandowski. Lewandowski first insisted that Nadler provide a copy of the Mueller report so he could follow along with the passages as Democrats read them. He then told Nadler that he does not remember the 2017 Oval Office meeting in which Trump asked Lewandowski to persuade then Attorney General Jeff Sessions to reverse his recusal and set new time limits on the Mueller probe, which laid out the special counsel's report. After Lewandowski paused in answering Nadler's questions, Republicans and Democrats battled over whether the clock should be suspended on the chairman's 5 minutes of questioning. I want you to take note that how that's sort of written in sort of a very sort of dispassionate way, just to tease what's going to happen. Yeah. Things quickly went downhill as GOP members pushed for an adjournment of the panel. Can't wait to see that. While Lewandowski said he would answer questions about the Mueller report, the White House sought to place limitations on the testimony of Lewandowski, who has never worked in the Trump administration. He worked on the campaign. Nadler said in his opening remarks that Democrats will not accept these limitations from Lewandowski, who is the committee's first fact witness and who they said was part of the president's effort to block Mueller's probe into possible obstruction. And they blasted the White House seeking to block his testimony that extends beyond the Mueller report under the claims of that discussions with Trump under executive branch confidentiality interests. So this is the first witness that is appearing before this committee on impeachment proceedings or something, but he's the first witness, and I think he's really setting the tone for what's going to happen going forward. It's just going to show how the parties can really get together and cooperate and treat Congress as the serious place that we all know it can be. I think it really sets forth the tone of what we can expect as this continues on. So for our brief legal discussion, just referring to the executive branch confidentiality issues, there's this long issue that's long been fought over whether the executive branch has privilege over the legislative branch. Legislative branch has oversight. Executive branch has long claimed that they have privilege to not answer certain questions. And this fight has been going on long before Trump ever came to the picture. So just FYI, whether or not the executive branch has privilege over Congress and to what extent. They've been fighting about, I don't know how long, decades and decades and decades. I'm sure it well precedes Nixon too. This is something that's been going on forever. But I think that's enough. That's enough tease. It's enough amuse-bouche. I think it's time for us to see what happened. It's time for us to really, I think it's time for us to really experience it and see what happened. So we're going to watch this this video. It's 11 minutes and 54 seconds. It is a compilation that's been prepared by someone else, and the underlying material is non-copyrighted because it was produced by the U.S. government. So, I think we can pretty much show this and see what's going on. So let's really enjoy it together in the spirit of bipartisanship, which I'm sure we'll soonly see reflected in what's going on. Let's really enjoy it together, guys. Okay. Just turn up that quality for you so you get that extra little bit of, yeah.
I recognize that the privilege is not mine, but I've been asked by the White House to, Congressman, I'd be happy to answer your question, or you can just have a conversation by yourself. But if you'd like to ask me a question, I'll be happy to answer.
I'm going to continue. The reason is
well, then don't ask me a question if you don't want to hear my answer.
My time. This is a House judiciary, not a House party.
So if you ask me a question, give me the opportunity to answer your question.
The very campaign the special counsel is investigating. I'd like my time restored, please, of his interruption. He called you in to do his dirty work in secret because he knew it was wrong. Well, we will expose the truth. The president cannot hide behind you any longer. And you should be here to be telling the truth, because the truth will set you free and the American people. I yield back.
The time of the gentlelady has expired. The witness may answer the question.
I don't believe there was a question, Congressman.
Very well.
Yes, there was.
Could you repeat the question? I didn't hear it.
I'll be happy to repeat the question.
It's just a rant.
Can't repeat the question.
I'll be happy to repeat the question.
Gentlelady's time has expired. The gentleman from...
Did you know the Attorney General had recused?
I will begin by recognizing myself for 5 minutes. Mr. Lewandowski, is it correct that as reported in the Mueller report on June 19, 2017, you met alone in the Oval Office with the President? I said...
Is there a book and page number you can reference me to, please? I don't have a copy of the report in front of me.
Volume 2, page 90. But I simply ask you, is it correct that as reported in the Mueller report on June 19th, 2017, you met alone in the Oval Office with the President?
Could you read the exact language of the report, sir? I don't have it available to me.
I don't think I need to do that, and I have limited time. Did you meet alone with the President on that date?
Congressman, I'd like you to refresh my memory by providing a copy of the report so I can follow along.
You don't have a copy with you?
I don't have a copy of the report, Congressman.
Mr. Chairman, I request that the clock be stopped while this charade is sorted out.
I'm sorry, Congressman, what page was it?
The clock should have been stopped and should remain stopped. Page 90, volume 2.
Okay, and which paragraph, sir?
He needs that copy of that report for some reason to answer this question, right? He just got to have it.
I'd like a reference, sir, so I can follow along on what you're asking.
Oh,
do you not have an independent recollection of whether you met with the President on that date?
Congressman, I'm just trying to find in the Mueller report where it states that.
Well, you have it in front of you. I gave you the page number.
Okay, where on page 90 is it, sir?
Mr. Chairman, you got to start the clock.
No, I don't have to start the clock when he's filibustering. Bottom of page 90.
Filibustering is a different issue. That's across the hall in the Senate. This is actual questions being done now.
Mr. Chairman, point of parliamentary inquiry, Mr. Chairman.
That's not
the gentleman will state his point of parliamentary inquiry.
Mr. Chairman, is it appropriate for a witness to refuse to answer a question and instead demand that we reference and point him to the... I'd ask that Mueller report be closed and the witness be directed to answer the question.
No, well, the answer is not appropriate, but it's on the bottom 2 lines of that page.
Now I can start.
This is the first fact witness in this hearing, helping set the tone for what's to follow.
Point of order. When will the clock start, Mr. Chairman?
Once the question's asked, Mr. Chairman, the clock should start.
Right under overview, second line.
Parliamentary inquiry, Mr. Chairman.
The gentleman, the witness.
Point of order.
The witness has the time.
Point of order is
a question. The witness
will answer
answer
overrides that. A point of order overrides that, Mr. Chairman, and you know that.
The gentleman will state his point of order.
Point of order is once the question has been asked and referenced properly to the witness to answer the question, the clock should start. It cannot be held while you and your counsel go over notes.
The gentleman is correct. The clock will start. And the witness will answer the question without further delay.
Yes, I see that in the report.
Thank you.
All
Did he
that
ever
for- yes,
discuss
I
with
see
you
that
any
in the
concerns
report.
that he may have committed a criminal offense?
The White House is directed not to disclose the substance of any discussions with the president or his advisors to protect executive branch confidentiality.
All right,
I recognize this is not my privilege.
Mr. Chairman, I make a point of order. Pursuant to Clause 2J, 2A of Rule 111, that the gentleman is out of order. He has exceeded the time limit under the 5-minute rule.
I will enforce the time limit under the 5-minute rule.
I challenge the ruling.
I am very.
I challenge the ruling of the chair.
The ruling of the chair is challenged. All those in favor of overriding the rule of the chair will say aye. Opposed, no? No.
Roll call.
Noes have it. Roll call is asked. The clerk will call.
Now
Where's
we're
the clerk?
arguing over the chair, which is always good.
I mean, this
Clerk will call the roll.
Now we're going to have a roll call to see whether or not we overrule.
Mr. Nadler?
The question is, will the ruling of the chair be overruled? My vote is no.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Chairman, there are 13 ayes and 19 noes.
Mr. Chairman.
Yeah,
Mr. Chairman.
please.
Point of order. Mr. Chairman, since the chairman has refused.
Gentleman is not recognized.
I will be.
The point of order is sustained.
Mr. Chairman.
I am very troubled that the White House counsel sitting behind you are preventing you from answering these very basic questions that go to the heart of the president's conduct we are investigating.
Mr. Chairman, I have a motion. Mr. Chairman, I have a motion.
You will wait for your motion until I finish this.
Point of order, then.
Not only
Point of
The
order has
guy
got to be recognized.
Not
to
in the
his
middle of-
left,
Yes,
that
it
other
does.
guy is the most senior Republican.
The motion is to, since the chairman is not following the House rules, I move to adjourn.
motion is to adjourn.
Motion to adjourn.
Point of parliamentary
Robert's
inquiry,
Rules of
Mr.
Order.
Chairman.
Motion to
Motion to adjourn beats
Point of
out all their
parliamentary-
motions.
If the Republicans on
Didn't
this
know these
committee are
things?
successful in this motion to adjourn, does that mean there will be no hearing and the American people will not hear from Mr. Lewandowski about his efforts to obstruct justice?
Yes, that's exactly what it
Okay,
means.
that's what I want.
It also could read, they could read the 3 times the
Motion-
previous already done it.
I have a point of parliamentary inquiry.
The motion is not debatable. As many as are in favor of the motion to adjourn.
I have a motion of parliamentary
As
inquiry.
many are in favor.
So Mr. Cicilline gets recognized for his
Motion
inquiry,
is
but I don't
not
get recognized for
debatable. As many as are in favor of the motion to adjourn say aye. Opposed, no? In the opinion of the chair, the noes have it. Roll call is requested. The question is
call,
on the motion to
Forrest.
adjourn. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
It doesn't matter. what it's
Mr.
about.
Chairman, there are 12 ayes and 19 noes.
The motion to adjourn is not adopted. Georgia for his questions.
Thank you, Mr. Chairman. This past few minutes was totally avoidable and also very frustrating in the sense that it is also now raised from our perspective a question of the privileges of the rules of the House, which could be discussed on the floor and probably will be, and possibly just the blatant running over of House rules. My concern is ethics violations as well. This has got to be run in a different way. It's okay to try and get your stuff out. It's okay to be frustrated, but it's also not okay to overrun House rules. The 5-minute rule is a House rule. It's not a committee rule, and it's not for interpretation by the chairman, whatever he feels like. It wouldn't be if I was the chairman or you're the chairman. That's not debatable. And you may not have got your last question in, but we've already discussed, and we're going to have a lot more discussion here in a little while on staff questioning, but there's plenty of time to get that last little question that you didn't get asked to somebody else. But is it worth breaking the House rules? And I know some in the audience don't care and some of the majority don't care. But at the end of the day, you're accusing a president of very high issues that we got to look at. You're accusing him and dragging it through in this committee for 8 months. We're doing this. So I think following procedures is something that you actually have to look at, because your idea is not really.
Point of order, Mr. Chairman. The time has expired.
Thank you, Mr. Chairman. Mr. Lewandowski, you are about like a fish being cleaned with a spoon. It's very hard to get an answer out of you. You felt kind of squeamish, like that fish that you are trying to be right now, being scaled. You felt a little squeamish about delivering that message, correct?
No, sir.
Well, why did it take you so long and you never even delivered it?
Correct. I never delivered the message.
Yeah, you chickened out.
I went on vacation.
You went on vacation. And so you put the message in the safe, in your home for safekeeping. correct? Before you went on vacation.
I took my kids to the beach, Congressman. That was more of a priority.
And President Trump was hounding you about when are you going to deliver that message, correct?
Completely inaccurate, Congressman.
Well, he asked you about it a few times, didn't he?
No, he did not.
Have you ever put any words that the president asked you to write down before in a safe? Or was this the first time you'd done that?
I believe it's my standard operating procedure when taking notes, Congressman.
So every note that you take of the president, you put in a safe? How big is that safe?
It's a big safe, Congressman. There's a lot of guns in there.
On January 2019, on the Chris Matthews show, a member of this committee was asked, do you believe the president right now has been an agent of the Russians?
That was me.
That member said, yes. Chris Matthews followed up and said, an agent like in the 1940s working for a foreign power? That individual responded, he's working on behalf of the Russians, yes.
Still believe that.
And, you know, Mr. Chairman.
The reason why he's saying a member is
gentleman
there's rules
from,
against referring to another person by name.
Arizona's got the time.
Arizona has the time.
I'd like 10 seconds added back on.
He's got 10 seconds in any event.
Do you believe that Vladimir Putin is sitting in his office right now in the Kremlin, laughing at what those on the other side of the aisle are doing, and believing that those on the other side of the aisle are useful idiots helping?
Objection. I have a point of order.
The lady will state her point of order.
I have a point of order. According to the rules, and the rules of this committee and the House rules, we cannot attribute derogatory names to our colleagues or motives to our colleagues. And I believe the gentleman said those on the other side of the aisle are idiots. This is a very sacred and somber responsibility. I've taken an oath of office, my good friend, just like you did. I am concerned about the Constitution just as you are, and I would not engage in any behavior that could be described as idiot. Never in my life or my colleagues have we ever discussed behaving like idiots.
I mean, actually, I didn't call anybody an idiot. I said useful idiot. And secondly, I asked the witness whether he believed that as part of Vladimir Putin's strategy, Vladimir Putin was being aided by useful idiots in America.
We as a nation would be better served if elected officials like yourself concentrated your efforts to combat the true crises facing our country, as opposed to going down rabbit holes like this hearing. Instead of focusing on petty and personal politics, the committee focused on solving the challenges of this generation. Imagine how many people we could help, or how many lives we could save.
Okay, kids. Well, that's all you need to know from that hearing. So basically, it descended into a complete shit show with everyone. So just to recap what we missed there, when he asked the question initially, he said, "Isn't it true that like it said in the Mueller report X?" And then he said, "Well, where in the Mueller report?" And so then they had because it really wasn't the question. Like, he wasn't asking like, you know, but he said like the way the question was asked is like, well, isn't it true that like the Mueller report said blah blah blah? I said, well, where in the Mueller report? So then they had to have like a 15-minute argument about whether or not he needed to have a copy of the report or not to refer to it and stuff. So it's like, yeah. And then there's all this stuff about Robert's Rules of Order, which I know very well. I used to be a certified parliamentarian. My certification has lapsed, but I used to know Robert. Well, I still know them really well. I'm just not certified anymore. But like, yeah, when you start going into Robert's Rules of Order, you know things have gone to hell. You know, so you start like ranking emotions, point of order. It's like I want, you know, roll calls for everything. I want to overrule the chair. You know, I want to move to adjourn, all this kind of stuff, and then I want to roll call for that and all kinds of stuff. And then he had this nice prepared statement about the executive privilege, about it's not my privilege to waive and all that kind of fun stuff that he was saying. So all that good stuff. It's fun times by all. So there you go. Now, someone asked about contempt of Congress. Is there such a thing as contempt of Congress? Sure, there's such a thing as contempt of Congress. What's the catch? Well, the catch is if you want someone to arrest them, who would that be? Well, who does arresting? The executive branch. And who's the privilege from? The executive branch. So the executive branch has told him not to answer the question. Congress says he's in contempt. They say, okay, go arrest him. And the executive branch says no. I'm not going to do that. because the executive branch gets to make determinations on who they arrest and who they prosecute and all that kind of stuff. So sure, Congress can hold them in contempt for all the good it will do. Now, for whatever it's worth, this applied equally on the other side. For example, Eric Holder was held in contempt by Congress, by then a Republican Congress, for not giving information on the Fast and Furious scandal, which, as you may or may not recall, dealt with gun running. It dealt with the ATF telling gun dealers to sell guns to people the gun dealers thought were pretty suspicious, and the ATF told them to do it anyway. And it turned out they were pretty suspicious because they were gang members and part of Mexican cartels and shit, and some of those guns wound up in Mexico, and some of those guns were used to shoot U.S. border agents. So that was super fun. And the Congress, then Republican Congress, wanted records from Eric Holder. And Eric Holder said, I'm not going to give it to you. And the Republicans said, you're in contempt. And then, of course, the then Obama administration said, well, that's real interesting, but I'm not going to go prosecute and arrest Eric Holder because we're the ones who told him to do it in the first place. So now this is same script, different party. Flip the sides. Now it's the Trump administration telling someone not to cooperate with Congress. Yes, Congress can hold them in contempt, but Trump administration isn't going to do anything about it because they're the executive branch and they don't have to. So there you go. All the fun time. Permission to treat them as hostile? Yeah, you can have permission to treat them as hostile, but, what does it matter? Sure, you can ask, well, actually, you don't need it in the first place. All permission to treat as hostile does is give you the permission to ask leading questions. But they can do that anyway. So they can ask leading questions because it's not a court of law, it's congressional. So they have their own set of rules. So it wouldn't make any difference to treat them as hostile because you can already ask leading questions and they can still say, I'm not going to answer, and then what do you do? So, there you go. So super fun times. I just thought it was fun that Congress is having this judicial branch hearing and it's kind of descend into a fun shit show. And I imagine it's going to just be more of the same. So yeah, they're not. And same thing with like all kinds of stuff. Congress wants Trump's tax records. If Trump tells the IRS not to give him the tax records, then we have a wonderful fight between the branches because there's a law that says Congress can get access to his tax records. Well, that's real interesting. But guess who controls the IRS? The President of the United States. And so we can just say, well, don't do it because I'm the executive branch. Yeah, I know there's a law that says you have to, but I'm in charge of the executive branch. So don't. What are you going to do? Find me in contempt? I'm the President of the United States. Well, whatever. What do I care? So fun times. Contempt of Congress is limited where contempt of court isn't. Well, contempt of court, you have the judicial branch, right? Judicial branch, that you can have the judge find them in contempt and all kinds of stuff. But yeah, I mean, even contempt of court, there's two different kinds of contempt of court. There's the in the moment contempt, and then there's the broader contempt. So criminal contempt of court would still have the same problem. But if someone's being asked in the court hearing, then the judge can deal with that immediately. But Congress doesn't have that power because, of course, they don't give it to them. So, yeah. Is it a constitutional crisis? I don't know if it's a constitutional crisis, Lynn. As I was trying to indicate, this has been an issue on both sides of the fence to varying degrees of hostility. This issue that we just saw is not a Trump administration issue. It happened under the Obama administration with Eric Holder. It happened, I'm sure, under previous administrations. It happened with Nixon and the Nixon tapes, and that all went to the U.S. Supreme Court eventually in that case. So, these kinds of tensions are not a Trump phenomena. So, I don't know if it's a constitutional crisis because, it's not exactly the first time this has ever happened. This kind of thing is, for better or worse, somewhat routine. It's separation of powers and them fighting each other. Congress says we have the ability to do oversight, and the executive branch says, well, that's real interesting, but we're in control of the police forces and stuff. So yeah, you have the oversight, but if you say go arrest them, we're gonna be nah. So whatever. Why would contempt of Congress be executive? Shouldn't it be judicial? Well, the charge is a criminal charge. So contempt of Congress is a charge, is a criminal charge. So you would if you wanted to charge someone with contempt of Congress, here's how you go about doing it. First, Congress has to declare the person to be in contempt. Then the U.S. prosecutor would bring the case to court just like any other charge. So they go to court, they'd arrest the guy, they'd have a trial, all the rest of the stuff. So all that fun stuff. So it's your normal, routine, run-of-the-mill criminal case, except the person who brings the initial complaint is Congress in this case, who then gets referred to a U.S. prosecutor to actually run the case. But in this case, who's in control of the U.S. prosecutor? Well, that would be the Attorney General. And who's in control of the Attorney General? That would be the President of the United States. So if the President of the United States says to some guy, hey, I don't want you to cooperate with Congress, and he says, okay, and he goes there and says, I'm not going to cooperate with you, and Congress says, you're in contempt. So he says, okay, and they says, okay, you're in contempt, and they refer it to the U.S. Attorney, and the U.S. Attorney says, I don't know, what should I do, boss? Attorney General, and the Attorney General says, I don't know, what should I do, boss? President of the United States, and the President of the United States says, well, I'm the one who told him not to cooperate in the first place, so I'm thinking, why don't you not prosecute it? And they say, okay, and they say, okay, and end of case. Because there's no one to prosecute it because the executive branch controls the prosecutors. So ta-da, that's how that magic happens. And again, this is not a unique Trump issue. This is not a unique Republican issue. This is not a unique Democrat issue. I won't, I'm not going to make a false equivalence analysis. I'm not going to try to say that they're equal on both sides. I'm just saying it's not unprecedented. This kind of thing has happened. It's happened in most administrations at some point where one or the other is complaining at the other of something. So this is separation of powers, and the judicial branch, if someone went to the judicial branch and tried to get an injunction, the judicial branch would say it's a political question because it started out in a political hearing. This entire thing starts political. So if Congress wants to say, oh, this is contempt of Congress, and the executive branch says, I'm not going to do anything, and someone went to court to say, court, make them do something, the court would say, it's a political question, you guys figure it out. And they wouldn't get involved. So ta-da, that's how that goes. So I just thought it would be really, really entertaining to watch that shit show. In fact, we're going to have part 2 of the live stream. So it is Constitution Day today. It is September the 17th, and every September the 17th is Constitution Day. It is a day, it's, I guess, a federal holiday. They passed a law saying it's a federal holiday, not that anyone gets it off, but it's Constitution Day. So in honor of Constitution Day and in honor of learning about separation of powers, I'm now going to read the entirety of the U.S. Constitution to you because I can. And it'll be a good opportunity for us to learn something educational in addition to just, having some fun. So why don't we do that? You got the day off? Well, happy Separation of Powers Day. So we're going to read the Constitution of the United States. UK, as I understand, you don't have one of these. So maybe that's why you're having problems. But we're going to read this, and we'll read this and try to have some stuff, and it'll be fun. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. All legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person who shall be a representative who shall not have attained the age of 25 years and has been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state when chosen. So to be a member of the House of Representatives, you have to be 25, you have to be a citizen, you have to be a citizen for 7 years, and you have to live in that state. But you don't have to be a natural born citizen. But there is an age requirement. You have to be 25. Representative and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to a service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct, referring to the census, which, as we all know, is coming up in 2020. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative. And until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representatives from any state, the executive authority therein shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment, as we were just watching. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. So, for those of you who don't remember, the 17th Amendment changed this. Before the 17th Amendment, senators were not elected. They were chosen by the state government. They're chosen by the Congress of the states. So they weren't direct elected before the 17th Amendment. Immediately after they shall be assembled, in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of senators of the first class shall be vacated at the expiration of the second year, of the class of second at the expiration of 4th year, and the third class at the expiration of 6th year, so that 1/3 may be chosen every second year. So 1/3 of the Senate gets chosen every 2 years. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall fill such vacancies. So in the event that someone is absent, they can choose who fills the seat. No person shall be a senator who has not attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he is chosen. The Vice President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. So the President of the United States is also the President of the Senate until, I think, 1970s-esque, but someone will check me on this. The Vice President actually presided in the Senate, and of course that doesn't happen anymore, but they are the President of the Senate. So, but they don't have any vote, and they don't have any power, so it's kind of pointless. The Senate shall choose their officers and also a president pro temp in the absence of the vice president or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try impeachments. When sitting for that purpose, they shall be on oath and affirmation. When the President of the United States is tried, the Chief Justice shall preside. And this actually happened when Bill Clinton was impeached. Then Chief Justice William Rehnquist was the presiding officer in the Senate during that impeachment hearing. So if Trump is impeached, then John Roberts would sit in the Senate as the trial judge of this proceeding. So we can all look forward to that if that actually happens. And no person shall be convicted without concurrence of 2/3 of the members' presence. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So all the Congress and Senate can do is kick you out of office and say you can't ever hold an office ever again. That's the limit of their power because it's political, not legal. The time, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations except as to the place of choosing senators. The Congress shall assemble at least once every year, not that that's a problem because they meet all the time now, and such meetings shall be on the first Monday of December, unless they shall by law appoint a different day. Right now it is the 3rd of January by law. So that's the first day of Congress's session, is the 3rd of January. Or whatever the nearest Monday after that is. Each house shall be the judge of elections, returns, and qualifications of its own members, and a majority shall constitute a quorum to do business, but a small number may adjourn from day to day, and may be authorized to compel the absence of absent members in such manner and under such penalties as each house may provide. So if you don't show up for your job, they can actually arrest you and force you to show up, and they have actually done that from time to time. In those cases, those officers work for Congress, so those issues don't apply. It's the sergeant at arms who works for Congress, so they will arrest you. Fun. Each house may determine its rules of its proceedings, as we just witnessed about that. Punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member, so they can kick you out of the club if you're not behaving. Each house shall keep a journal of its proceedings, and from time to time publish the same, except such parts as may be in their judgment require secrecy, and the yeas or nays of the members of each house on any question shall, at the desire of 1/5 present, be entered into the journal. Neither house during the session of Congress shall, without consent of other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except treason, felony, and breach of priests, be privileged from arrest during their attendance at session of their respective houses. So if they're actually in session on the floor, you can't arrest them. You have to wait till they leave the building. And going to and returning from the same, and for any speech or debate or in either house, they shall not be questioned in any other place. Now that last clause I like quite a lot. It's called the speech and debate clause for various obvious reasons. But when it says, for any speech or debate in either house shall not be questioned, I interpret this, and I'm not the only one who thinks so, I interpret this as saying up to and including a member of Congress during a floor speech revealing national security secrets or violating security orders or whatever. Like anywhere else, it would be a violation of law to just randomly say, here's some classified information. But if you do it during a speech on the floor, it's not illegal. So there's a nice little trick. So if you ever get elected to the United States House of Representatives and you want to say that aliens really exist, there's your clause for you. You can do it. They can't arrest you. Nice to know. No senator or representative shall, during the time for which he is elected, be appointed any civil office under the authority of the United States which shall be created. So you can't work for two branches of government at the same time. That's what that says. Or the emoluments whereof shall be increased during such time. So your pay can't increase while you're serving. And no person holding any office under the United States shall be a member of either house during its continuance in office. So you can't be a member of the executive branch if you're in the legislature, and you can't be a member of the legislature if you're a member of the executive branch. You can't serve in more than one branch at the same time. All bills for raising revenue, taxes, shall originate in the House of Representatives. Only the House of Representatives can increase taxes. But the Senate may propose or concur with amendments as to other bills. Each bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approves, he shall sign it. But if not, he shall return it, with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If, after such reconsideration, 2/3 of that House shall agree to pass the bill, it shall be sent together with objections to the other House, where it shall be likewise reconsidered, and if approved by 2/3 of that House, it shall become law. Veto override. The president can veto stuff, but they can pass it anyway. But in all such cases, the vote of the House shall be determined by yeas and nays, and names of persons voting and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the president within 10 days after it shall be presented to him, the same shall become law. So if you just sit on it for 10 days, it becomes a law. Unless but Congress by their adjournment prevent its return, in which case it shall not be law, which is called a pocket veto. So if the Congress passes something at the end of its term and they're not in session, then the president can veto it by just letting it die. It's called a pocket veto when that happens. Every order, resolution, or vote to which the concurrence of the Senate and House may be necessary, except on the question of adjournment, shall be presented to the President of the United States. And before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives according to the rules and limitations prescribed in the case of a bill. So anything that has to be signed has to be signed. Very good. All right, delegated powers, kids. This is something that conservatives like to pay a lot of attention to. So this is what Congress has the power to do. The Congress shall have the power to lay and collect taxes, duties, imports, and excises, to pay the debts and to provide for the common defense and general welfare of the United States. But all duties, imports, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. They do plenty of that. To regulate commerce with foreign nations and among the several states and with Indian tribes. That would be the Commerce Clause, which is a bit of a pain in the butt. Here's one that's ever popular right now. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof, and of foreign coin, and to fix the standards of weights and measures. To provide for punishment for counterfeiting the security and current coin of the United States. To establish post office and post roads. My favorite clause. To promote progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their writings and discovery. That would be copyright and patents. To constitute tribunals inferior to the Supreme Court. They can create lower courts. To define and punish piracies and felonies committed on the high seas and offenses against the laws of nations. They have the right to punish international law. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and war. To raise and support armies, but no appropriation of money to that use shall be longer than for a term of 2 years. To provide and maintain a navy. To make rules for government and regulation for the land of naval forces. This would be the UCMJ. All of our military friends will be well familiar with this. To provide for calling forth the militia to execute the laws of the United States, suppress insurrection, and repeal invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the services of the United States, reserving to the states respectfully the appointment of officers and the authority and training of the militia according to the discipline prescribed by Congress. So this would now be what we would consider to be the National and State Guards. To exercise exclusive legislation in all cases whatsoever over such a district, this would be D.C. they're talking about now, not exceeding 10 miles square, and it was when it first started, but now it's smaller than that because Virginia's portion was given back to Virginia, so it's a little smaller than that now. As may, by secession of the particular states and acceptance of Congress, become the seat of government of the United States, and to exercise the like authority over places purchased by the consent of legislatures of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So Congress has all legislative power as it concerns D.C. As a practical matter, D.C. has something called home rule. Congress passed a law that says basically the mayor gets to determine what the law is, but Congress can just change that anytime they want, because Congress has all the power over D.C. To make all laws which shall be necessary and proper for carrying execution of the foregoing powers, and all other powers vested by this Constitution, the government of the United States, or any department thereof. So anything else that we didn't think of, that's a lot of stuff. The migration or importation of such persons as of any of the states now think shall be proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 per person. Right there, they're talking about slavery, in case you're confused, because they're using obscuring language because they don't want to say it outright. But when they're talking about migration or importation of persons, they're talking about slavery. So that's good. The privilege of writ of habeas corpus shall not be suspended unless case of rebellion or invasion, the public safety may require it. And under the relevant case law, basically, as long as the courts are operating, privilege of habeas corpus exists. No bill of attainder or ex post facto law shall be passed. A bill of attainder would be where Congress passes a law just flat out saying that someone is guilty of a crime. That's a bill of attainder. Congress can't do that. Ex post facto law is criminal and refers to making something criminal that wasn't criminal at the time you did it. So you can't look backwards in time and say, oh, that's criminal now. If it wasn't criminal then, it's not criminal then. So Congress can't pass a law saying you're just flat out guilty of something, and Congress can't make something criminal after the fact. That's probably reasonable. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. So they're talking about income tax, but the 16th Amendment changed that. No tax or duty shall be laid on articles exported from any state. Congress can't tax the exports of a state. No preference shall be given to any regulation of commerce or revenue to the ports of one state over another, nor shall vessels be bound to or from one state be obligated to enter or pay duties to another. So you can't charge duties or taxes from one state to another state. No state can charge another state taxes. They can't charge excises and dues. There's freedom of travel, freedom of goods, freedom of importing. No money shall be drawn from the treasury, but in consequence of appropriation made by law, and regular statement and accounting of receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States. Sorry, guys, you can't be a king or anything. It's just not happening. And no person holding any office or profit or trust under them shall, without consent of Congress, accept any present, emolument, office, title of any kind from any king, prince, or foreign state. From time to time, foreign governments have wanted to give people like royal titles, and Congress has actually from time to time had to debate it. And I think it's happened, but it's not common as a result of this. So if you want to be named a prince of something, you have to get Congress to say okay. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing obligation contracts, or grant any title of nobility. States, you can't do this stuff. Don't try. The U.S. government can't do it. You can't do it either. No state shall, without consent of Congress, lay any imports or duties or imports or exports, except where it may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imports lay any state on import and exports shall be used for treasury, and all such laws shall be by revision and control of the Congress. So I believe Hawaii does do some stuff when it regards to importing and exporting fruits and stuff like that. So that's what gives them that kind of leverage, but obviously, it can't be more than is required for the need. So it's very tightly construed. No state shall, without consent of Congress, lay any duty of tonnage, keep troops, or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in a war unless actually invaded or in such imminent danger as will not admit of delay. States cannot go to war. The executive power shall be vested in a president of the United States. He shall hold his office during the term of 4 years, and together with the vice president, chosen for the same term, shall be elected as follows. Each state shall appoint in such a manner as the legislature thereof a number of electors, equal to the whole number of senators and representatives to which a state may be entitled in Congress, but no senator or representative or person holding office of trust or profit shall be appointed elector. So this would be what we lovingly call the Electoral College. So every state appoints the electors who actually elect the president. This clause has been abrogated, but we'll read it anyway, or it's been abrogated in part. The electors shall meet in their respective states and vote by ballot for 2 persons, one of whom shall not be inhabitant of the same with themselves. So that clause is still operational. So you can't have, it's inadvisable to have the president and vice president be from the same state, because if they are from the same state, then you run into problems where you can't actually vote for both of them. So that's a problem. And they shall make a list of all persons voted for and the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of government in the United States, directed to the President of the Senate. So the states vote their electors, and then they send them sealed to the Congress. That actually happens. The President shall, in the presence of the Senate and representatives, open all certificates, and the vote shall be counted. And that actually happens. It happens in January. It happens on January 3rd in the presidential election year. So there's an election in November, and then Congress gets elected, and they meet on January the 3rd. So on January the 3rd, this is what they do. They actually elect the President of the United States. So the actual election of the President of the United States actually happens on January 3rd or thereabouts when Congress counts the votes. The person having the greatest number of votes shall be president. If such number be a majority of the whole number of electors poisoned, and if there be more than one who has such a majority and has an equal number, then the House of Representatives shall immediately choose one of them for president. If no person has a majority, then from the 5 highest on the list, the House shall choose an elect banner. So if no one has the requisite number of votes, then the House of Representatives actually gets to decide. This has happened before. It hasn't happened recently. But it could happen, particularly if there was a third party that gained enough traction to gain enough seats. That was how it happened in the past. But yeah, if there's not 270 electoral votes, then the House of Representatives just picks somebody. So that's super fun. But in choosing the president, the vote shall be taken by the states, the representative for each state having one vote. So when the House of Representatives is choosing, it's not that each representative gets one vote. It's each state gets one vote. So the states have to figure out amongst themselves who they're voting for. So if you're Alaska, you only have one person. You get to consult with yourself. If you're California, you've got, 53 or something. So the 53 of you have to figure out who your one vote is going for. That's what it says. A quorum for this purpose shall constitute a member or members from 2/3 of states, and a majority of all states shall be necessary to choose. In every case, at the choice of president, the person having the greatest number of votes of electors shall be the vice president. But if there to be two or more have equal vote, the Senate shall choose. So the House elects the president, and the Senate elects the vice president. So hypothetically, they could elect different people. So that hasn't happened in a while, but it's possible. It's in the rules. The Congress may determine the time of choosing electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So Congress gets to determine when the election occurs, and it is the first Tuesday after the first Monday in November every year, or every election year. No person except a natural-born citizen or citizen of the United States at the time of adoption of this Constitution shall be eligible for the office of President. Neither shall any person be eligible for the office who shall not have attained the age of 35 years and been 14 years a resident within the United States. So as long as you're natural born, you can be president, but only if you've lived here for 14 years. So if you've lived overseas, I don't know what to tell you. In the case of the removal of the president from office or his death or resignation or inability to discharge his powers and duties, the same shall devolve onto the vice president. And Congress may by law provide for a case of removal, death, resignation, or inability of both the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or the president shall be elected. The president shall, at stated times, receive for his services a compensation which shall be neither increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any emolument from the United States or any of them being the several states. And we know how popular the emolument clause is these days. Before he enter on the execution of office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer of each of the executive departments, that would be the cabinet, upon any subject relating to the duties of the respective offices, and he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have the power, by and with the consent of the Senate, to make treaties, provide 2/3 of senators present shall concur, and he shall nominate, and by advice and consent of the Senate shall appoint ambassadors, other public ministers and counsels, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein provided for, and which shall be established by law. But Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the course of law, or in the heads of the department. So the President makes all the appointments, and if not, then it is the members of the Congress, the cabinet, who do. The President shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions, which shall expire at the end of the next session. So if Congress is not in session, he can just make appointments, which does happen, somewhat controversially sometimes. Okay, this next one is for the State of the Union. He shall from time to time give Congress information on the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them with respect to time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care of the laws be faithfully executed, and shall commission all officers of the United States. The President, Vice President, and all civil officers of the United States shall be removed from office for impeachment and conviction of treason, bribery, and other high crimes and misdemeanors, which is what we were referring to earlier today. The judicial power of the United States shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. The judges, both Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuation of office. The judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made, or whom shall be made under the authority, to all cases infecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies in which the United States shall be a party, to controversies between two or more states, between a state of a citizen and citizens of another state, between citizens of different states, between citizens of the same state claiming the lands of grants of different states, and between a state or the citizens thereof and foreign states, citizens and subject. So basically, if you got states fighting each other or citizens of different states fighting each other, then you got the Supreme Court has jurisdiction. Now, this is a fun one. This refers to the time when the Supreme Court is the trial court. In all cases affecting ambassadors, other public ministers, and councils, and those to which the state shall be party, the Supreme Court shall have original jurisdiction, which means they are the trial court. So that saves time because there's nowhere to appeal to because of the trial court. In all other case mentioned, the Supreme Court shall have appellate jurisdiction, both as the law and fact, with such exceptions and under such regulations as Congress shall make. And someone said, hello, New York versus New Jersey. That's right. If anyone saw that CGP Grey video recently, you might have saw when they were listening to the audio, they said some number and then they said original, right? You said something like 34 original. Well, that's what they're talking about. When they say original, that means we are the trial court and we're the appeal court. We're all of those things at the same time. Excellent. Saves time. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in state where said crimes have been committed, but when not committed within any state, the trial shall take place at places as Congress may by law direct. Treason against the United States shall consist only in levying war against them or adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or in confession of open court. The Congress shall have the power to declare punishment for treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person obtained. So if you commit treason, only you're responsible. We don't get to hold your children and your children's children is responsible. So I'm looking at you, North Korea. If someone commits treason, you don't get to blame them for 7 generations as far as the United States is concerned. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of any other state. So every state has to honor what every other state does. And Congress may by general laws prescribe the manner in which such acts, recordings, and proceedings shall be proved and effect thereof. The citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. So basically, a state cannot treat you as a foreigner. So whatever they give their own citizens, they have to give to you. Which is nice. Allows me to travel from state to state and not be treated differently. It's plus. A person charged in any state with treason, felony, or another crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction. So we have extradition procedures within the United States. So, if you're wanted in New York, but you're found in California, New York has to extradite you. But it's not very hard. They just have to ask, and they just send a formal letter, and that's pretty much it. But they still have to go to court and ask. So you can get extradited within the United States. Who knew, right? No person held to service or labor in one state under the laws thereof, escaping to another, shall in consequence of any law or regulation thereof be discharged from service or labor, but shall be delivered upon the claim of the party to whom such labor or service may be due. Again, talking about slavery, and this was super fun and popular during the Fugitive Slave Acts days when people would flee from one state to another, and we got things like, the wonderful decisions that sparked so much of our country's history on dealing with that. So That's where that came from. New states may be admitted to the United States in this union, but no new state shall be formed or erected within the jurisdiction of any other state. Nor shall a state be formed by the jurisdiction of two or more states or parts of states without the consent of the legislature of the states as well as Congress. So if you want to carve out part of a state to become a new state, you have to get permission of the states concerned, and Congress also has to say okay. And the only time that's ever happened is in the case of West Virginia, because West Virginia used to be part of Virginia, but now it's not. The Congress shall have the power to dispose of and make all needful rules and regulations respecting territory to the property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States of any particular state. The United States shall guarantee to every state in this union a republican form of government. That has been held by courts to be mostly a political question, but there are some very, very narrow exceptions, but that's well beyond our scope. And shall protect each of them against invasion, and on application of the legislature or the executive against domestic violence. So that's talking about insurrection, talking about rebellion. So if there's an active civil war going on in some state, they can ask, would you please help us? And of course, the U.S. government can get involved. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or in the application of legislatures of 2/3 of the states, shall call a convention for proposing states. So there's two ways to get an amendment proposed. You can either get the legislature to do it, or you can get the House and Congress to do it. So only the first method has ever been chosen. Every amendment has come because the Houses of both Congresses have passed it, but there is an alternative clause. It's called a convention of states. You may sometimes hear about this. Some conservatives want to do it. I think it's a bad idea, but it's allowed for by law. So you can bypass Congress completely to get amendments. Now, the rationale for that is pretty obvious, right? If you want to amend something and Congress is hostile because you're going to take away their power, you need an alternative mechanism. So the states can just say, screw you, Congress, we're just going to do it ourselves. So there's a remedy for that in that contingency, which in either case shall be valid as to all intents and purposes a part of the Constitution when ratified by the legislatures of 3/4 of the several states or by conventions of 3/4. So again, there's two ways to do this. When you're actually looking to it, you can either get the legislature to do it, or you can do it by a convention, which is basically a popular vote. And I believe the only one that's ever been done by convention, I think, is the 21st Amendment. So it's normally the legislature, but there is an alternative mechanism there too. Just in case the legislature is hostile to what you're trying to do, you can do it another way. Or one of the other mode of ratification may be proposed by Congress. Provide no amendment shall be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article. Basically saying prior to 1808, you can't propose an amendment that ends slavery. So that's just super popular. And no state without its consent shall be deprived of equal suffrage in the Senate. So that is still binding. So you cannot propose an amendment to the Constitution that would take away Senate seats from a particular state unless that state says yes, and why would they? So that's still unconstitutional. You can't propose that amendment. All debts contracted and engaged herein before the adoption of this Constitution shall be valid against the United States under this Constitution as under the Confederation. So anything that happened under the Articles of Confederation is still binding, so we're still going to pay our debts. The Constitution and laws of the United States shall be made in pursuance thereof, and all treaties made which shall be made under the authority of the United States shall be the supreme law of the land. Federal law beats state law, and judges in every state shall be bound therein, as anything in the Constitution or laws of any state to the contrary notwithstanding. So your local laws and your local Constitution are subordinate to our Constitution. The senators and representatives before mentioned and the members of the several state legislature and all executive and judicial officers, both the United States and several states, shall be bound by oath of affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office of public trust in the United States. So I like that clause quite a lot. So we're a secular country and they can't require you to prove that you're religious. That's nice. The ratification of conventions of 9 states shall be sufficient for establishment of this Constitution between the states, so ratifying. And then we have some errata, because they couldn't be bothered to rewrite it. Here's the errata. The word "the" being interlined between the 7th and 8th lines of the first page, the word 30 being partially written on an eraser in the 15th line of the first page, the words "is tries" being interlined between the 32nd and 33rd lines of the first page, and the word "the" being interlined between the 43rd and 44th lines of the second page. Done in convention by the unanimous consent of states present the 17th day of September, that would be today, Constitution Day, baby, in the year of our Lord 1787, and of the independence of the United States of America the 12th, in witness whereof we have subscribed our names. So, hey, today's Constitution Day. Today is the day the Constitution became a thing. So, happy Constitution Day. So, 1787 to 2019. Still going strong, guys. And then we got a letter of transmittal, which we don't need to read. All right, let's read some amendments, baby. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peacefully assemble, and to petition the government for a redress of grievances. For those of you counting, that is 5 separate things. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner prescribed by law. So they can't put soldiers in your house. That's nice. The right of the people to be secure in the persons, houses, and papers and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or thing to be seized. No person shall be held to answer for a capital or otherwise infamous crime unless presentment on indictment from a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in times of war or public danger. So that would be our UCMJ friends again. So if you violate the laws of the military, you're on your own. Nor shall any such person be subject to the same offense be twice put in jeopardy of life or limb, double jeopardy clause. Nor shall any person be compelled in any criminal case to be a witness against himself, right to remain silent. Nor shall they be deprived of life, liberty, or property without due process of law, due process clause. Nor shall private property be taken for public use except without just compensation. That would be eminent domain. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against himself, confrontation clause, to have compulsory process for obtaining witnesses in his favor, defense gets to subpoena people, and to have assistance of counsel for his defense. That would be me and Leonard. You have the right to have one of us stand up in court. So, hey, plus. In suits at common law, where the value of controversy shall exceed $20, the right of trial to a jury shall be preserved, and no fact tried to a jury shall otherwise be re-examined in any court of the United States than according to the rules of common law. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So just because we didn't mention it, doesn't mean that it's not a right of yours. They thought ahead. The powers not delegated to the United States by the Constitution nor prohibited to the states are reserved to the states. So the federal government is one of limited powers. The states have all the powers that are reserved. So that is, of course, an issue that is always in constitutional law in tension. 11th Amendment. 11th Amendment's history is very interesting because the Supreme Court ruled on something and then they hated it so much they passed the Constitutional Amendment to overrule a Supreme Court decision. So this is maybe the only example of that happening, but it happened. The judicial power of the United States shall not be construed to extend to any law, suit of equity, commenced or prosecuted against one United States citizen of another state or by citizens or subjects of foreign states. So this deals with, states suing other citizens. And they hated it so much, they passed an amendment to undo it. The electors shall meet in their respective states and vote for the ballot by president and vice president, one of whom, at least, shall not be an inhabitant in the same states with themselves. They shall name in the ballots the person voted for as president, and in distinct ballots the person voted for as vice president. and they shall make distinct lists of all persons voted for as president and all persons voted as vice president, number of votes of each, which list they shall sign and certify, and transmit sealed to the seat of government of the United States, directed to the president of the Senate, which is the vice president of the United States, as we learned earlier. The president of the United States, that is, the vice president, shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall be counted. The person having the greatest number of votes shall be present, if such be a majority of the whole number elected. If no person has a majority, the person having the highest numbers not exceeding 3 on those shall be voted for president. So in the Constitution, originally they said 5, and they said, well, that's just too many. Well, let's narrow it down to 3. See. But in choosing the presidents, the vote shall be taken by states, the representative of each state having a vote. So each state gets one vote. A quorum for the purpose of determining the member from 2/3 of states, a majority of all states shall be necessary to choose. And the House of Representatives shall not choose a president when the right of choice shall be devolved upon them before the 4th day of March, and that's changed because that used to be inauguration day, the 4th day of March, announced January the 20th, as we all know and love. The vice president shall act as president in the case of the death or continuous disability. The person having the greatest number of votes as vice president shall be vice president. And such number of majority, whole number of electors be appointed, and no person having a majority then from the 2 highest on the list. So the House gets their choice of 3, the Senate gets their votes of 2, and they choose independently. Super fun. A quorum for the purpose shall be 2/3 of the whole number of senators, and a majority of the whole number shall be necessary for the choice. But no person constitutionally ineligible to the office of president shall be voted for vice president of the United States. So if you can't be president, you can't be vice president. So there you go. Neither slavery nor involuntary servitude, except as punishment for a crime where the party shall be duly convicted, shall exist within the United States or any place subject to jurisdiction, and Congress shall have the power to enforce this. So no slavery unless you've been convicted of a crime, which some people think is a pretty big loophole, but I'll leave that for another time. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. So if you didn't know, according to the 14th Amendment, you are a citizen. If you're a citizen of the United States, you're also a citizen of your state. I bet you didn't know that, but it's right there in the 14th Amendment. See, it says, are citizens of the United States and of the state where they reside. So you're a citizen of your state. Who knew? Now you do. No state shall make or enforce any law which shall breach the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny to any person equal protection of the laws. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. So we changed that whole 3/5 thing, the slavery thing. We kind of changed that, went to the whole numbers. Probably a good thing. When the right to vote of any election for choice of electors for President of the United States, representatives of the elected executive and judicial officers, or members of any legislators denied to any male inhabitants of such states being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation shall be reduced in proportion to which some number of male citizens shall be the whole number of male citizens 21 years or age of older. So it used to be only males got to vote, and you had to be 21. And of course, both those things changed. No person shall be a senator or representative of Congress or elected president of the United States or hold any office, civil or military, under the United States or any state who previously taken an oath as a member of Congress or as an officer or as a member of any state legislature or as executive or judicial officer of any state to support the Constitution shall have engaged in insurrection or rebellion against the same or given aid or confidence therein, but Congress may by 2/3 remove disability. So if you engage in civil war, you can't be part of the club unless they say you can be part of the club. And I believe they changed that, including for Jefferson Davis, if memory serves properly. So I'm not sure how effective that was, but they put it in there. The validity of public debt in the United States authorized by law, including debts incurred for payments of pensions and bounties for service of suppressing insurrection, shall not be questioned. But neither shall the United States nor any state shall assume or pay any debt or obligation incurred in the aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations shall be held illegal and void. So, you don't get a takings clause issue for slavery. We've just declared slavery illegal, and no, you don't get money for it. Screw you. The Congress shall have power to enforce this by appropriate legislation. The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on accounts of race, color, or previous condition of servitude. The Congress shall have the power to enforce this by appropriate legislation. The Congress shall have the power to lay and collect taxes on income from whatever source derived without apportionment among the several states and without regard to a census or enumeration. So that would be your income tax. So originally in the Constitution, as we read before, the income tax had to be apportioned. So if you want to charge an income tax, you had to apportion it, which means it had to be broken up so it was even by the number of citizens and even by the number of people, but you don't have to bother with that anymore. Now there's no apportionment. So now you can do your income from any source of income, and you don't have to worry about that apportionment stuff and balancing anymore. So all that South sits, this is their favorite clause of the Constitution, right, guys? The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof. Okay, just as a personal FYI or personal note, I never quite understood why there's 2 senators per state. To me, that doesn't quite make sense. Why not 1 senator per state? I don't understand the rationale of having 2 senators per state. To me, it seems like an odd choice. I understand each state having the same number of senators. I don't have a problem with that. But especially when they were directly appointed, it seems like you'd only have to have 1. Because if you have only 1, they're like this quasi-ambassador. That's the way I thought of it, right? Because they're separate states. They're separate nations, but they're part of this united whole. So the way I sort of interpret the Constitution is look, we have representatives of the people in the House, and we have representatives of the state in the Senate. But why do we have 2 per state? That's really odd. That'd be like a country having 2 ambassadors, which to my mind doesn't make any sense. So it makes a lot more sense to have 1 senator per state. And that way, the people have their elected representatives, which is based on the number of people, and that makes sense, right? So more people, more representatives. But in the Senate, every state gets 1 senator who's in this sort of quasi-ambassador role, who represents the state as a whole. And he's appointed by the legislature. So he represents the voice of the state government, and then you have the voice of the people, and it makes more sense. So I never quite understood why we have 2 senators per state. It seems odd. Why not just 1 senator per state? Doesn't make sense to me. But I don't know, and that's what they wrote. So that's what we're stuck with. Carrying on. Each senator shall have 1 vote. The electors in each state shall have qualifications requisite for the electors of the most numerous branch of the state legislature. When vacancies happen in the representation of any state in the Senate, the executive authority therein shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments. So basically saying what we said before. And this amendment shall not be construed as to affect the term of any senator chosen before it became valid. 18th Amendment. Boo. After 1 year from the ratification of this article, the manufacture, sale, of transportation of intoxicating liquors within and the importation into or the exportation thereof of the United States in all territory subject to the jurisdiction thereof is hereby prohibited. Boo. The Congress in several states shall have concurrent power to enforce this article by appropriate legislation. This article shall be inoperative until it shall have been ratified as an amendment to the Constitution by the legislature of the several states as provided in the Constitution within 7 years of the date of submission. So they banned alcohol. It was very, very sad. I'm very, very sad. It was a bad amendment. I hate it. Moving on with our lives. The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. And Congress shall have the power to enforce this. So women get the votes. Very good. The term of the president and vice president shall end the 20th day of noon. So it used to be the 4th of March, and now we're changing that to the 20th day of January. And terms of senators and representatives at noon on the 3rd day, as I said, of the years in which the terms would have ended if this article had not been ratified, and terms of their successors shall begin. So someone got shortened a little bit on their presidential term. Someone whose term was supposed to end on March the 4th got shortened a little bit there. So, well, what you gonna do? The Congress shall assemble at least once every year, and such meetings shall begin at the noon of the 3rd day in January, unless they shall appoint a different day. And they don't, it's always the 3rd day of January. If at the time fixed for the beginning of the term of president, the president shall have died, the president-elect shall become president. So if the president dies in the interim, the vice president becomes president. So we don't have to deal with that problem, right? So, we elected a president and he's died, and we got this vice president sitting around. So what are we supposed to do? Well, he just becomes president. So we solved that problem. That was nice. If a president shall not have been chosen before the time acted for beginning of the term, or the president elected shall fail to qualify, the vice president shall act as president until a president shall have qualified. And Congress may by law provide for a case in which neither president nor vice president shall be qualified, declaring who shall then act as president, or a mayor who shall be elected to act, and such person shall act until someone qualifies. So we deal with that contingency. The Congress may by law provide for the case of death of any person for whom the House of Representatives may choose a president, whatever right of choice shall devolve upon them, and for the case of death of any person for whom the Senate may choose a vice president. So this is the scenario. This would be a scenario where there is not enough votes to directly elect someone. So remember how we were going to send 3 people to the House and 2 people to the Senate? Well, what if one of those people dies? What if one of those people dies in the interim? Well, we've got a contingency for that too. Now we have a system that says basically, so if one of those guys dies, the House can just randomly replace them with someone else. So that would be fun, right? So imagine this fun hypothetical, guys. Imagine we have an election in which there's no majority for the Electoral College. So the House of Representatives has to decide, and one of them dies. And then Congress says, oh, now this is the candidate, and by the way, we're electing them. So that would be super popular, but hey, they can do that. Fun times. Sections 1 and 2 shall take place the 15th day of October following ratification, and this article shall be inoperative unless it has been ratified by 3/4 within 7 years. So they put in a limitation. 21st Amendment. Yay! Yay! The 18th article of the amendment to the Constitution is hereby repealed. Yay! Liquor's legal again. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of laws thereof is hereby prohibited. So basically saying that states and territories can still ban alcohol if they want, but it's not unconstitutional. Thank God. This article shall be inoperative unless it shall be ratified, blah, 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 whatever. 22nd Amendment. No person shall be elected to office of the president more than twice. And no person who has held the office of president or acted as president for more than 2 years of a term to which some other person has been elected shall be elected to the article more than once. So this is dealing with a contingency when someone becomes president if someone else dies. So if the president dies and the vice president becomes president, the operative question is, how long has that been true for? So if it is more than 2 years, you can only run once. If it's less than 2 years, you can run twice. So hypothetically speaking, someone could be president for 10 years. So 10 years is your limit, not 8, because you can serve 2 of someone else's term, just in case you want to know. But this article shall not apply to any person holding the office of president when this article was proposed, and shall not prevent any person who may be holding the office of president or acting president during the term when this article becomes operative from holding the office of president or acting as president during the remainder of such term. So that was talking about Truman, and of course Truman didn't exercise that, so that's moot. This article shall be inoperative unless it's ratified within 7 years. Amendment 23, D.C. gets some votes for president. The district constituting the seat of government of the United States shall appoint in such manner as Congress may direct a number of electors to president and vice president equal to the number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. So they get 3. And they shall be in addition to those appointed by states, but they shall be considered for the purposes of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of the amendment. So D.C. gets 3 votes in the Electoral College. That's how you get to 538, in case you wanted to know. D.C. gets 3 votes in the Electoral College. Very exciting for them. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors of president and vice president, or for senators or representatives shall not be denied or abridged for any reason for failure to pay any poll tax or other tax. So you don't have to pay a tax in order to vote, because that was a thing they tried, and that was bad, and so they prevented that from happening. 25th Amendment. In the case of removal of the president from office or death or resignation, the vice president shall be president. Whenever there's a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirmation of a majority of both the House and Congress. So if the vice president dies, the president appoints someone else, and it has to be confirmed by both houses of Congress. And of course, this has happened. In fact, it was Ford, right? Ford was never elected as either president or vice president because he was nominated and then confirmed, and then he took office. So yeah, that's actually happened. Whenever the president transmits to the president pro tempore of the Senate and Speaker of the House of Representatives written declaration, he's unable to discharge the duties of his office until he transmits to them a written declaration of the contrary. Such powers and duties shall be discharged by the vice president as acting president. So the president can temporarily set aside if he wants by just sending a letter, which is usually done when the president is undergoing general anesthesia, but the clause is not limited. So if the president needs to step aside for some temporary reason, he can. Are you allowed to be VP if you've already been president for the maximum term? It's never happened. I mean, I guess hypothetically, yes, because you could still be president for 2 years. So you could become VP but then like you're in this weird space where you would only be able to serve up to 2 years. So I don't know what would ever happen, but technically I guess it's possible. Whenever the vice president and a majority of either the principal officers of the executive departments, that would be the cabinet, or of such other body as Congress may by law provide, transmit to the president pro tempore of the Senate and the Speaker of the House of the Representatives their written declaration that the president is unable to discharge the powers and duties of the office, the vice president shall immediately assume the powers and duties of office as acting president. So, for those of you not following along, if the vice president and a majority of the Congress if the vice president and a majority of the cabinet write a letter to the president pro tempore saying the president is unable to serve, the vice president immediately becomes president of the United States. So that's a thing that exists. Thereafter, when the president transmits to the president pro tempore of the Senate and Speaker of the House his written declaration that no inability exists, he shall resume the powers and duties, unless the vice president and majority of either the principal officers or such other body as Congress may by law provide transmits within 4 days to the president pro tempore and Speaker of the House the written declaration the president is unable to discharge. So, the vice president and a majority of the cabinet write a letter saying the president's unable to serve. The president writes a counter letter saying, yes, I am. The vice president and a majority of the cabinet write a counter letter saying, no, you're not. That's where we are now. Thereon, Congress shall decide the issue, assembling within 48 hours for that purpose of non-session. If Congress within 21 days after receipt of written declaration or Congress's non-session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses, the president is unable to discharge the powers and duties, the vice president shall continue to discharge the same as acting president, otherwise the president shall resume. So basically, the vice president and a majority of the cabinet can basically excise the president of the United States for at least 4 days, and depending on Congress's mood, up to a month, basically. So that's a thing that exists. The right of citizens of the United States who are 18 years old, age or older to vote shall not be denied or abridged by the United States or any state on account of age. And the 27th Amendment, which has a wonderful little history because it was part of the original Bill of Rights. This was originally the Second Amendment. This was 2 out of 12. Yeah. So this is originally the Second Amendment, and it's stuck around for 200 plus years, and, you know, good times. No law varying the compensation for services of senators and representatives shall take effect until an election of representatives has intervened. So basically, Congress cannot increase its own pay during its own term, and that is the end of that. So that was the entirety of the Constitution of the United States. So that was a good way to celebrate Constitution Day. I mean, all things considered, it took a while to read, but, you know, it's not that long, all things considered, for something that's governed the country for like 200 plus years. Yeah, FDR was elected 4 times. He died in his 4th term. So, yeah, good times. So, what happens if both the president and vice president dies? Under current law, the Speaker of the House becomes president. And if the Speaker of the House is unavailable, then the president pro tempore of the Senate becomes president. And if the President Pro Temp of the Senate is unavailable, then it goes in order of cabinet officials based on when the cabinet position was created. So I believe next up is Secretary of State, and then Secretary of Defense, and then it goes down the list from there. So that is the order. So it's President, Vice President, Speaker of the House, President Pro Temp, and then it is Secretary of State, Secretary of Defense, and then other people. So that's what happens if those various people die. Now, there is a big caveat to that, the big caveat being that you have to still be qualified to be president. So if you happen to hold one of those positions and you are not qualified because you're too young or some other reason, not a natural born citizen, because you don't have to be a natural born citizen to hold those other positions. So they just skip over you. So yes, if Donald Trump is unavailable, then it becomes Pence. If Pence is unavailable, then it would be Nancy Pelosi. If Nancy Pelosi is unavailable, it is the President Pro Temp, who is, I believe, Mitch McConnell, I think. And then it would be Secretary of State and Secretary of Defense, and I don't know who those people are because they keep changing them too much. So that's how that goes. But that's the order. Very exciting. And then the last cabinet position I believe that was created was Secretary of Homeland Security, sort of like 28th on the list. But yeah, that's and then of course we have the whole designated survivor thing. So, during the State of the Union is the most notable time because everyone's in the same room except for one guy. And so they call him the designated survivor. They never allow everyone in the same room all at the same time. So, the Secret Service gets pretty paranoid when all the cabinet meets for very obvious reasons. But even then, of course, like the Speaker of the House isn't in the cabinet meeting, nor is the President Pro Temp. So the only time they'd all be in the same room is the State of the Union. And during the State of the Union, they have one guy who's a cabinet member who sits in a bunker somewhere, and just in case someone blows up the Capitol. And there was a whole TV show called Designated Survivor starring Keith Sutherland that's built around this premise. He was the Secretary of Education or some crap. And they blew up the Capitol, and bam, you're president of the United States. So that's how that goes. So yeah, we have contingencies built for this. So very, very exciting. So let's see. Yeah. If there's any other questions? Let's see. Take any other random constitutional questions because it's Constitution Day in case you guys have any. Yeah, that's good. Housing, housing and urban development. There you go. So Keith Sutherland in the show was Secretary of Housing and Urban Development. Yeah, but they always pick a guy. It's usually like someone that's not particularly notable. Which in the event of total catastrophe, it's like you might want to be someone notable, but hey. It's got to be somebody. So you have a contingency for that. So the Secret Service deals with all that fun stuff. So fun times had by all. Can we abolish the Constitution? Yeah, sure. Why not? You could pass an amendment just undoing the whole thing, I suppose. You could have a new constitutional convention just creating a new one. So I suppose you could do that. We undid the Articles of Confederation. So you can undo the Constitution. Sure, why not? Well, I hope this has been an entertaining stream. I'm so happy that 15 of you are now joining and watching me at the same time. I seem to be getting more concurrent viewers, so I'm taking that as a positive sign. I'm hoping you're also liking the release schedule and the videos that I'm doing. I've got some more ones queued up, so that's good. And this weekend, I think it's going to be for the stream. This weekend is going to be watch Uncle Blackleaf lose his shit because there was some stories in legal news that really irritated me. And I'm going to react to them and lose my mind. So that should be entertaining. We may drink on stream. Leonard doesn't drink on stream. I have no such prohibitions, I assure you. We might break a cigar. Who knows? It can be whatever we need to do. So, hey, that's fine. So, yeah. Anyways, for now, my friends, I hope you're well. Till later. Cheers and goodbye.